I don't care. Just gonna, if it's at 1:30, you're gonna be behind whatever we're doing.
We can take it up now. My client's here.
All right. Ms. Huey, you are here today, and my understanding is that you have filed, again, representing yourself pro se in this case as well, that you have filed a series of motions, one of which is to establish a buyout procedure, authorize a transfer of interest, and to impose deadlines, motion to compel responses to requests for production of documents.
Yes, sir.
I'm going to allow you to have an opportunity to argue your motions if you want to address the first one, which is the motion to establish buyout procedures.
Yes, sir. Your Honor, I'm seeking disentanglement and finality in exiting this ownership relationship. I've been displaced for nearly a year and continue incurring approximately $2,500 a month in housing costs while my equity of over $250,000 remains tied up and the timeline continues to expand. I'm requesting a structured path forward that allows resolution rather than continued expansion of timelines and uncertainty. Their current processes involve multiple personal property auctions while the real property, the primary asset, remains without defined listing timelines or endpoint. I'm simply requesting a structured buyout process and the ability to transfer my ownership interests with successor recognition so a purchaser may step into my shoes without disrupting proceedings or prejudicing the proceedings at all. I also have a 13-year-old child, and the prolonged uncertainty is directly affecting my ability to provide stability and move forward.
All right. This is a case that the court has heard motions in before, and I think there's already an order down that ordered that the property be placed for sale, and that it listed the method by which we're doing it. So you're actually asking me to change the prior order of the court, but so far all I've heard is you're asking to set some sort of structured transfer process that would be more expeditious, but how exactly are you proposing that that be done other than by selling the property by realtor?
So Judge, I'm asking that if I'm able, or if I have the opportunity to sell my interest to an investor or third party so that I may exit the structure and the structure that you set forth for selling the property can continue and someone simply step into my place.
Well, I don't think there's anything that would prevent you from selling your interest to a third party, but the third party would have to be advised that there's ongoing litigation and that this case has already been, this is a partition suit, which means that owners of property that no longer wish to be co-owners of the property have an absolute right to partition the property. There are two methods by which the property can be partitioned. One is by partition in kind, where you divide the property up equally in value, and real property is oftentimes very difficult to do that. Well, this is a house, is that correct?
It is a house.
Yes, sir.
So it's very difficult to arrive at a partition in kind, which means the only other way is by selling the property. You have an interest in the property. If you want to sell your interest to a third person, then you can do so, as long as it doesn't complicate or restrict what happens in this case, because we already have a court order that sets in motion the sale and liquidation of this property.
Yes, sir. Thank you. I just wanted clarity from the court that that process would be allowed and that those successor rights could pass.
Let me hear from Mr. Osborne, who represents the other parties. Mr. Osborne, you may need to, the prior person was a little shorter than you are, so.
Thank you, Judge. Your Honor, Ms. Huey's got multiple motions that she has filed before the court, so I'll address both the motion to establish the buyout procedure as well as the motion to authorize the transfer of interest that she has filed. Judge, as you have rightly pointed out, the court heard a prior motion in this matter on February the 12th of this year. During that motion, which was a motion to authorize the auction of the personal property as well as the listing of the real property, the personal property being auctioned with Mr. Neil Trice and the real property being listed for sale with Ms. Beth Thornton and Ms. Carrie Carrington as co-agents. Now at that time, Judge, there was no opposition stated by Ms. Huey. In fact, everybody announced that they were in agreement with this proposed course of sale. That order entered. It became final. There was no opposition, no appeal filed to that order. We would just ask that that order be left in place, that the process be allowed to carry out. I did speak with Mr. Trice this morning. He said the first auction of the personal property took place this weekend. He said that it went very well, had a great turnout. Several items were sold. The second auction of the personal property is scheduled for July 11th, I believe, this summer. Once that is taken care of and the personal property auction is completed, at that point, Ms. Carrington and Ms. Thornton can proceed with getting the property listed. Respectfully, Judge, we would ask that the parties just maintain the status quo and allow this sale to go ahead and take place. Marketable title has got to obviously include any co-owners signing off on the listing agreement. Ms. Huey had previously indicated she was fine to list the property with Ms. Thornton and Ms. Carrington. They've both spent a decent amount of time, as I understand, going out, viewing the property, making recommendations on what needs to happen for showings. So we would ask that, again, the court just allow the existing order to stay in place, that the parties not make any transfer of the ownership interest, and that whenever this personal property auction takes place in July, parties can then immediately list the property with the agents, and hopefully it'll get sold pretty quickly. This is in a good area of the county. It's just off Spencer Mill Road. That area has historically done very well, especially here in the recent few years. I think the property will do quite well, but again, Judge, we would ask that the process be allowed to play out as set forth in the February order.
All right. Ms. Huey, the problem is that there's already an order down that establishes how this property is to be sold and liquidated and how the partition is to go forward. And that order went down and more than 30 days elapsed from the entry of the order. So therefore, under the rules, that becomes an order that's a final order. As a result of that, I am not going to make any changes in that procedure because of the fact that making a change in it would simply delay the process that we've already entered into. And I think that the process that we're engaging in right now is the best and most efficient way to liquidate this property and to try to obtain the best and most valuable price for the property for all concerned. Now, Mr. Osborne raises a point because Mr. Osborne's firm deals with title searches and so forth, and he's well aware that while I indicated that there was nothing that would prevent you from liquidating your interest and transferring it to some other party, the problem is if you were to do that and it were to interfere with the transfer of the sale of the real property because it complicates the title, then by allowing you to liquidate your interest, it complicates and restricts and makes more difficult and more expensive that interest that the process that we're engaging in to try to liquidate this property. For that reason, I am ruling that the prior order of the court as far as how this property is to be sold is going to be the order of the court that will take full force and effect, and that there will be no changes and that no party will be allowed to transfer any interest in the property until such time as the real estate property is, in fact, under contract to be sold. What that does, I think if we have an auction of the personal property, then the real property becomes much more marketable, and then I think that you'll see that there's a much better price of this. I understand your economic situation, but your economic situation does not require the court, unfortunately, to restrict the rights of the other parties that are involved in order to perhaps aid you in your situation would be detrimental to the remaining parties of this lawsuit. And for that reason, I cannot grant your request to allow you to liquidate your interest or transfer your interest to some third party that would then complicate the transfer of title at the sale of the property. There is a motion to compel responses to requests for production of documents. Is there?
Judge, if I could just address that briefly. This is Ms. Huey's second set of discovery requests that she has sent to us. She does have a set of discovery requests from us that still needs to be sent. The pending discovery from us includes a set of requests for admissions. Her second set of requests for admissions, I believe that was 95 that she sent on the second request.
95 requests for admission?
Yes, sir. That she sent to us. We have coordinated with Mr. and Mrs. Sproles. We've compiled answers to those. We had made efforts to get those executed electronically via DocuSign. Mr. and Mrs. Sproles were having issues with their email. Ms. Huckabee, one of their other daughters, who is also their attorney in fact, has met with me this morning right before court. She has executed those requests for admissions. I will be getting those over to Ms. Huey following court today. There is also a pending set of requests for production of documents. Judge, this is a rather voluminous file. That box contains all the documents we are trying to go through and compile, but again, given the volume of documents, we have not been able to get those over yet. We anticipate getting those done in the upcoming weeks. Mr. Belmars did file a response proposing a scheduling order if the court thinks that's necessary. But again, the other set of discovery requests, we intend to get those out to her as soon as we can.
Well, Ms. Huey, your
He went to
request
marriage
for production of
counseling in
documents, the second set of
2024,
production of document requests.
somewhere around June, I
that entail
believe.
90
And
some
this was
odd.
one of the things that we talked about.
There is a
And
point where
so one
both
of the
sides
things
have
that
the
the
right
marriage
to obtain
counselor got us to
information
kind of come together
necessary
on
in
was my gym
preparing their
stuff.
case for,
And so
excuse me, for a hearing.
we both agreed that it
But
would be
there is
really
a
good
point where the court
to
finds that the
make sure my
discovery
gym time
process can
fit,
be abused.
in
And
the
as a result
mornings
of that,
at 6 a.m., which
I'm going to
didn't
give
really
the,
affect things at the time because
petitioners 30 days to
not that
respond
part,
to
but
your discovery
whenever I was going at
requests.
lunch, we had Bryson
And if
daycare, so
they have an objection
it
to it,
was
then they
helpful
may
for
do so.
weekends and stuff like
Any
that.
further
But that was the
discovery
point where
requests,
I went fully
if
with
Mr. Osborne and the
before
petitioners
they were awake and
find
full
that
work.
that is excessive, then
And
they
then
will be able
I
to file a
did
motion
do
to quash
both lifting
those
and
discovery
cardio,
requests.
like a stair climber.
Discovery
and
requests
I
are
would go
intended not to be
during my lunch
punitive in
breaks for
nature.
that.
They're intended to allow you to
But was that
obtain
always a source of
information.
controversy
But
with her that you-
90 some odd requests for admissions, or a request for admission is just basically saying you admit that the following to be true or false, or deny it. And it's oftentimes used in a method to try to force the issues, but I am of the opinion that 90 requests for admission, is that what they were, requests
Yes.
for admission?
Yes.
May be excessive under the rules, but in any event, we'll give them 30 days to file a response and either object or provide the information requested.
Your Honor, if I may, I just want to clarify, they were not meant to be excessive. They were directed toward issues that the plaintiffs themselves had placed on issue, including offsets, reimbursement claims, property expenses, accounting issues, ownership issues, and factual assertion. So I was simply seeking clarity. I was not intending for them to be overbroad or excessive.
All right, I'm not saying that they were excessive, but I'm just saying that there is a point where you become, it becomes excessive when you're in a discovery process. So just be careful to make sure that that doesn't arise. And Mr. Osborne, being the good lawyer he is, will file an objection to them if he believes that it has become excessive. All right, then 30 days to respond to the discovery responses. The court finds that the motion to establish a buyout procedure, authorize transfer of interest, impose deadlines is denied.
Thank you, Judge.
Thank you, Ms. Huey.
Thank you.
Good morning.
I represent Mr. Lestoff in this divorce that was filed on March 12, 2026. Subsequent to my being engaged by Mr. Lestoff, I filed a couple of motions. They are set to be heard on the 26th. Mr. Holly came in on last week, I guess, and is now representing the wife. He filed a couple of motions. He set those for today. Unfortunately, we were not able to agree to continue to the 26th. I'm asking that the motions all be heard on the 26th. Please.
Your motions were already filed
Yes, they were.
and they were set for the 26th?
Yes, Your Honor.
Then why would we not have everything on the 26th?
Judge, if I may,
You may.
with your restraining order was all based on an arrest. That arrest has been pulled. That being said, I can't get a visitation. I canceled the problem. I think after I filed some of mine. counsel here about really not being able to agree to
Well, if there's an emergency situation, then that would be different, but it sounds like to me there's just a division, an opposition to it. It would appear to me that this case, already having been set by Mr. Parsley on the 26th, that any motions that were going to be joined would necessarily, unless it was an emergency situation, would necessarily have to be heard on the 26th as well. So I'm going to move it all to the 26th with the understanding that Mr. Parsley, your client, needs to understand that when we get to the 26th, if there's been a showing that there's been an unreasonable denial of visitation to Mr. Holly's client, that will be a factor that the court will consider in making the decision. So I expect there to be a cooperation with your client. If there is no basis upon which now to withhold the children, then she needs to be able to see the children. All right, we'll move them to the 26th.
Thank you, Your Honor.
Thank you, Judge.
All right, then that puts us back on our first contested case of Cuff versus Cuff.
Judge, it's ready.
Well, he needs to sign it, so. And I guess that's the signature line for the judge, but we'll see. Hand it to me whenever we get to it. All right, Cuff versus Cuff. I need the file, please. This is for final hearing, correct? Either party wish to make an opening statement? So let me make sure I'm understanding. You appeared before Judge Turnbow and entered an agreement to resolve the grounds for divorce and the property, and then you shifted the custody decision over to me. That's pretty much what happened. But I know Judge Turnbow's in his office today, not dressed for court, but, I didn't know if you needed him to come in and hear it.
Well, Judge, I don't know that it matters being dressed for court. Y'all have your robes on, so it's up to yours. We were set here on we came before the court, and Ms. Duke and I were able, the house actually got sold. We got a contract on the house. And as a result of that, that enabled us to kind of get the property issues resolved because there was a contract on the house. And so that's what we did. We ended up, both parties wanted a divorce. We agreed the wife would be awarded a divorce, and then divided all the assets. So that left only the custody determination to be made. Previously, I was not originally the counsel that filed this petition, but there was a pendente light order that was entered back in April of 2025. And again, Judge Turnbow, as my understanding, that it was that they announced an agreement at that point in time. Ms. Duke, wasn't that correct?
That's accurate.
It wasn't a hearing. Judge Turnbow was the judge presiding there, but there wasn't testimony at the time. The parties were able to reach an agreement, and then they went to mediation and were unsuccessful.
I don't care if,
So- Yeah.
all I'm saying is you had everything else in front of Judge Turnbow and you resolved it. I wasn't sure exactly why this custody issue wasn't,
Because you
heard.
you were the next one in line.
That's fine.
That was it.
And I'll be glad to hear it.
There wasn't any testimony on the pendente light hearing that would necessitate going back, and it was just the fact that we settled it when Judge Turnbow was here last month, and so you had an available time. So we
Right,
said,
that was the April 7th, 2025 pendente lighting motions, order rather. All right,
yes, sir. And that's what the parties have been going by. Your Honor, these parties, again, as we said, we stipulated grounds for divorce. They've been declared divorced. The parties have one minor child, Bryce, who will be 4 years of age come this September. At the time of the separation, the mother remained in the home. The father moved out in an apartment. Mr. Cuff filed for divorce, and he filed a parenting plan where he was asking for an equal residential schedule, 182.5 days each. They came to a hearing and announced an agreement wherein the mother was designated as the primary residential parent, the father was designated the alternate parent. And the father, they split the child, although not on an equal basis, but pretty close. The father had the child from Friday at 3 until Thursday at 7 a.m. when the child would be dropped off at daycare. And he did that every other week. And then on the alternate week, he had from Sunday to Tuesday. So effectively a 2-4 schedule with the father. As I said, Mr. Bryce will be 4 years of age come this September. My client works as a software, in the software industry and works from home. He has kind of a unique schedule wherein that he works a lot of evenings because he deals with foreign customers, and he has to keep that schedule so he's available effectively to be there for the child. The mother, as I understand, works a split 2 days home, 3 days at the office schedule with more traditional hours. Both parties are capable parents. Both parties loves the child, and this is just a unique situation, Your Honor, where they can, a 50-50 schedule would be appropriate. My client is asking to be designated as the primary residential parent, and we would ask, and the reason for that, Your Honor, is effectively that they would have joint decision-making, but if somebody had to effectively make the decision, he would ask to do that. Both parties have provided the day-to-day caregiving of the child, both capable and able-bodied to do it, both have jobs that lend themselves to be able to have a 50-50 residential schedule. And again, Your Honor, that's what we're requesting.
When you say a 50-50 schedule, what are you?
Well, Your Honor, at the time, the schedule that Mr. Cuff, when his previous attorney, Ms. Lowe, was practicing, he asked for a split from a Friday to Tuesday and then a Saturday, but again, the week-to-week, he's about to be 4 years of age, and I think a week-to-week schedule would be appropriate. If the child was any younger, again, possibly where the child doesn't go 7 days without seeing either parent. But I think in this situation, a week-to-week schedule, or in the alternative, a 2-5-5-2 schedule would be what we would be asking for, such as he would have, as I understand it, Ms. Cuff has 2 days she works remote and 3 days that she is in Brentwood, where her employer is. And so again, designating if she has those set days that he would have, again, effectively Monday, Tuesday, she would have Wednesday, Thursday, and they would alternate the weekends, so it would effectively be 2-5-5-2 if you wanted to do something less than a week-to-week. So those are the two schedules that we would propose that would be appropriate for Bryce. And again, what goes along with it, there hasn't been any indication through discovery that either party intends to relocate outside of Dickson County, but we would request that Dickson County be designated as the school that the child goes to. Again, within Dickson County, there's several different, whether they're Charlotte, White Bluff, or Dickson or Burns. Again, we would ask that Dickson County be designated as where the child goes to school.
Duke?
Your Honor,
The rule has been requested. If there are any witnesses other than the parties that need to go outside and remain outside until you're called to testify, you're not to discuss the testimony of any other witness until you yourself have concluded your testimony. So. All right, anybody that's going to be a potential witness? All right, go ahead.
Judge, what Your Honor is going to hear today is that the mother has always been the primary residential parent, making sure that this minor child is cared for. When Ms. Roberts stated what the current schedule is, it was a little off. I think she just misspoke regarding one of the days. The current schedule is Friday to Tuesday and Sunday to Tuesday. So it's a 3-2 split. And I would submit to the court that when that schedule was established, it was established with the parties' work schedules in mind. I would submit to the court that the father, I think he's quite bold in asking for primary residential parent in that He has completely thrown his marriage away with a paramour wherein he was repeatedly leaving this minor child for the mother to take care of, which was fine with the mother, and flying across the country for an internet sex hookup. And as I understand it,
An
Mr.
internet sex hookup.
Yes, Your Honor. He met a
According to the file, you're saying it was Washington State that he was going to?
Yes, Your Honor. And he was flying there routinely, specifically when the child had a overnight stay at the hospital. Father took off and went on to Washington State instead of sticking around to find out if the child was okay. Father has left the child, I wouldn't say neglected. I'm not going to say that he is a bad father, but he has chosen sex and a girlfriend over his minor child. And that does put him in a questionable light as far as this court is concerned regarding his ability to care for the minor child. I think the court's going to have to glean from some of the things that Your Honor hears today that he's quite deceitful about his time with the minor child and when he's actually exercising his time. We built into the temporary schedule a provision wherein if the father was not going to be with the minor child for a period of time, that he would contact the mother to allow the mother to have the child. Proof is going to show today that repeatedly he, during visits, has gone to the gym and spent more than 2 hours there with his girlfriend watching over him while he's there. The girlfriend is the internet sex hookup, now girlfriend, maybe fiance. He's been wearing a ring, though I'm not sure he's got it on today. Your Honor's going to find that he was required not to have the minor child around the girlfriend, fiance, whatever she is, but he has routinely video gamed with she and her children, and the minor child has been exposed during this time period. He's had difficult time following the court's orders. Court's going to find that he would leave early in the morning at like 4 a.m. to go work out at the gym, leaving the mother with the burden of caring for and getting the child up for daycare and getting the child to daycare. I will say he did pick the child up from daycare routinely, but he cast his family, including the minor child, aside for this woman in Washington. I think the court's going to find that when he could exercise time with his child, he chose to go to Washington instead of being with the child. So that's the crux of the case. We are going to need to calculate child support today. Your Honor is going to have to rule on visitation. We are asking that based on the agreement of the parties originally for what would work best for this child, that remain the case. I think the mother could come before this court today and ask that he just get an every other weekend schedule, because frankly, I think that that's what he wanted on the front end, but was pressured by his family to ask for something different. I think his text messages are going to show that. The text messages, I will say also, the text messages show that he specifically, when he was cheating on his wife, made arrangements with the girlfriend saying, I can't come to Washington until I have a custody order in place. And so he was being manipulative of this court. He was being manipulative with the wife. He was being manipulative with the child in order to try to get what he wanted custody-wise. Your Honor is going to have to consider that there are daycare expenses involved in this matter, and we're asking for the mother to be able to make all the decisions, or at the very least make the final decision with regard to decision-making.
All right, Ms. Roberts, you may call your first witness. Yeah.
Well,
I've read through the file. The file shows that it's Friday at 3 p.m. to Tuesday at 7 a.m.
Yes, it's
when the
morning.
father drops a minor child off at daycare every other week. And then Sunday at 6 p.m. to Tuesday at 6 p.m. on the alternate week.
That's correct. And so it'd be a 3.5-day, 2-day.
Like that Mr. 8981 can do that.
Fair enough.
State your name for me, please, sir.
Matthew Tyler Cuff,
And Mr. Cuff, you presently reside where?
638 East Forest Park in Dixon, Tennessee.
And how long have you lived over at East Forest Park?
Since the end of February of 2025.
Okay, and that's where you moved when you vacated the marital residence? Is that
Yes, ma'am.
correct?
Yes.
You and your wife, your ex-wife now, Mrs. Kayla Michelle Cuff, lived where together?
We lived at 534 Country Club Drive in Dixon, Tennessee.
And when, did y'all purchase that home together?
Yes, we did.
And again, you heard Ms. Duke's opening wherein you just, vilified you, that you abandoned your family for sex. Is that true?
Yes, I heard that.
Heard that, but that wasn't a true statement.
No, ma'am.
Let's talk about your commitment to your family, sir. You and Mrs. Cuff married when?
June 3rd, 2018.
And
Mr.
at
Cuff,
that-
pull that microphone towards you just a little bit, the bass will slide. There you go.
Yes, Your Honor.
Thank you.
So again, repeat, when did you marry?
June 3rd, 2018.
Okay, and was it a first marriage for both of y'all?
Yes, ma'am.
And tell me at the time, what were you doing when y'all married? What type of job did you have?
I was a software engineer.
And the same thing that you're doing now, is that correct?
Yes, ma'am.
And what did Miss Cuff do?
She worked as LPN for a cosmetology company.
Okay, and is she still an LPN?
Yes.
And is she still working for the same company?
No, ma'am.
And you know where she's working now?
She's working at Mattify Health.
And what does she do there?
I think she's a clinical operations director.
And did she go up in the food chain, if so to speak? Was she working and is she doing better for herself now?
Yes.
And y'all decided to have a child during the course of your marriage, is that correct?
Yes.
And you have Bryce.
Yes, ma'am.
What's Bryce's full name?
Bryce Cameron Cuff.
And how old is Mr. Bryce?
He's 3.5.
And he will be, I believe, 4 in September of this year, is that correct?
Yes.
Now, during the course of your marriage, when y'all married, where were you living and where was she?
Before we married, we moved in together before we got married. We were living in Brentwood at an apartment. Do you want the address? 127, I think it was Crestview Drive in Brentwood, Tennessee.
And whose apartment was that? Did y'all rent that together, or did you move in with her, or she moved in with you?
We moved in together.
Okay. And so y'all were both working in the area?
Yes.
Okay. Now, you have family here in Dixon, is that correct?
Yes, ma'am.
And who are your people?
My mom and my dad,
What are their names?
David and Debbie Cuff.
And where do they live?
They live right down the road, 522 Country Club Drive.
Okay. And does she have people in the area?
She does.
Her people?
She has a large family. I have a rather small family. She has her mom that lives here in Dixon, and then the rest of her family live in White Bluff, and then I think her sister lives in Burns.
Okay. So again, she has people in this area, and at some point in time, y'all moved in together and then decided to formalize your relationship, is that correct, and got married?
Yes, ma'am.
Did you own a home, or did you have any real property at the time?
No, ma'am.
And y'all decided to purchase a home here in Dixon?
Yes, we did.
Was that before or after y'all discovered that you were going to have a child?
That was before we had a child. That was one of the things that we wanted, was to have a house to raise him in.
And what measures did you take in order to ensure he?
I received several large raises, and so I used the extra raise that I got to be able to pay for a mortgage along with my family, also helping out with a down payment.
Along with your family, what was that?
Our first house, my dad gave me $20,000 from his 401k, and my late granddad gave me $10,000 to put down as a down payment.
So you had about $30,000 down payment, is that correct?
Yes, ma'am.
And you used that to purchase your first home?
Yes, ma'am.
Where was that first home?
161 Caraway Court in Dixon, Tennessee.
And was it purchased during your marriage?
Yes,
And
ma'am.
was it placed in both of your names?
Yes.
Okay. But you got family money to purchase so you and your wife could have a home to start a family.
That's correct.
And then subsequently, y'all moved over next door to your parents.
That's correct.
And did you make any additional payments, or was it all marital money that went into that?
My grandmother passed away, and they my mom was kind of the person managing, like it went to her. And so my granddad always wanted me to have the house that was next to them, but to take care of my grandmother, they had to sell the house for her care. And so my mom, after my grandmother passed away in February of 2024, I believe, she gave me $265,000. That was my inheritance from my grandmother that I put towards the house.
$265,000 and $30,000 of your separate money you went in to establish a home for your family, sir. Is that correct?
Yes, ma'am.
And I take it your now ex-wife said, "Tough luck, I want half of everything," didn't she?
Yes, ma'am.
She didn't acknowledge the fact that your family had made a commitment so that y'all could raise your child here in a community where your families live, did
I'm
she?
going to object as to relevance, number one. Number two, the parties have an agreement. He
Absolutely.
agreed as much as she did. So
Your Honor, Ms.
I don't
Duke,
know that that's relevant.
Ms. Duke in her opening argument vilified my client, thinking that he's some sex fiend running off to Washington State to have sex, and that he left his family, and how dare he do that. And again, I have every right to put on what the commitment that this man made to his family and to his children.
I am overruling the objection, allowing the evidence in to rebut any inference that may come up during the defendant's proof regarding his failure to provide adequately for the family or his abandonment of the family. Obviously, what happened then is not necessarily applicable to what happens now, but it does show a history. So overrule the objection.
So again, you committed a significant amount of your separate money in order for your family. Why did you do that?
So that we could have a really nice home to raise Bryce in. And we were 5 houses down from my parents, and my mother is going to be retiring at the end of this year, so we were intending to use them, for childcare and to help out, pick them up from school, things of that nature. So, yeah, and we wanted a backyard so that we could put a playground in the backyard for our son, and we did.
Okay. And again, at no point in time during this did you dispute that that the home was a marital asset, and we entered an agreement, did we not, to divide that asset in an equal portion?
Yes, ma'am, we did.
Okay. Now, let's just get on to, before we get to some of the other things concerning it, you started having an affair, didn't you?
I did.
Okay, tell me what led to that.
We had some issues in the marriage where that we had kind of grown apart, and somebody reached out to me online, and we chatted. It was a very short period of time, about 10-ish days before I actually told Kayla that I wanted a divorce and left the marital home.
Okay. So again, when you said reached out to you online, you put something out there.
Yes, at the time I was working out. I used to be really large, and
When did you used to be very large?
I was at my biggest at around 2020, right before my granddad passed away, and he had congestive heart failure, and I was really scared that if I continued down that path, that was going to happen to me, and so that inspired me to try to lose weight, and I did.
And when did you, and this was during your marriage?
Yes, ma'am, it was.
I guess your grandfather died a couple years into your marriage.
He did.
Okay. And so so you were working out?
Yes, ma'am. And I was posting just videos of me, lifting weights on TikTok and Facebook and Instagram.
Did you go on some dating app?
No.
Okay. Again, when you said she reached out to you, you were posting things on social media.
Yeah. Yes, ma'am.
And some person reached out to you.
Yes.
And who was that person?
That was Ashley Doty.
And she's here today.
She is.
And once y'all made contact, did you begin a romantic relationship?
We did shortly thereafter.
Okay. And did you hide this from your wife?
Initially, yes.
How long did it happen? How long were you involved in this relationship from when it started until you moved out of the home?
Approximately 10 days.
Okay. And what prompted you to move out of the house?
I was unhappy in the marriage, and I think that I felt that it was probably in my son's best interest to in the marriage and move on.
And when did you disclose to your wife that you were having an extramarital affair?
She found out, I think it was early March, maybe around March the 10th. And I think she saw the phone records, and then confronted me, and then I said that that's what was going on.
Did you lie to her first?
I did.
How long was it before you came clean and told her that you had started one relationship before you finished the other one?
Just under a month, I believe.
And had you already gone out and met with this lady?
Uh,
Or was it simply when did you become physical with your girlfriend?
So I left the marital home and then met her like that next day.
Okay. And then and after you had left the marital residence, your wife found out about the relationship?
Yes,
Okay. Now, when you left, did you get this apartment that you're living in?
I did.
Okay, and that's where you've been. When you left, did you and she work out any arrangement for your son, Bryce?
We did.
And what was that arrangement?
At the time prior to the hearing on April the 2nd, we were exercising 50-50 custody.
Okay, and what does that, explain what that means? I mean, practically speaking, I got Monday, Tuesday, she got Wednesday, Thursday, I got a week, she got a week. What is your
right.
interpretation of 50-50 custody?
We were doing, it was, I believe, a 3-4 split. So it was, I had him for 3 days, she had him for 4, and then I had him for 4, and she had him for 3.
And how long did that work out?
That worked out up until the April the 2nd hearing.
Okay. So, getting this correct, this woman reaches out to you on the internet.
Yes, ma'am.
You respond back.
Yes, ma'am.
Y'all start discussing things, y'all start talking verbally or just texting, and what did y'all do?
It was both. We were texting, and then we would talk on the phone.
Now, this young lady, her name is, again, what is her name?
Her name is Ashley Doty.
And Ashley lived in Washington State
Yes, ma'am.
and is married, or was married at the time.
Yes, ma'am. She had filed for divorce and was wedded, but she was still married.
And does she have children?
She does. She has 2 children.
And how old are her children?
Her children are 6 and 10.
And so y'all start having a conversation, and you decide that y'all have something in common and want to further your relationship. Is that correct?
Yes, ma'am.
You're still living in the marital residence at the time?
Yes, ma'am.
And then what? You tell your wife you're not happy and you're moving out?
I did.
Okay, and you moved out.
I did.
Your wife finds text messages and sees numbers on your phone
Yes, ma'am.
and finds out that you're talking to another woman.
Yes, ma'am.
And in fact, it had sex with that woman at that point in time.
At what point?
Well,
When-
when she found out, had you consummated your relationship with your girl?
Yes, ma'am.
Okay. And so when you moved out, saying you're not happy, y'all started this 50-50 division.
Yes, ma'am.
And you continued that. When did you move out again?
Moved out on, I believe it was February the 23rd.
So a few days in February, all of March, and until you went to court in April.
That's correct.
And you had gone on and
I do.
continued your relationship. Go
I
ahead.
need to amend that. So it was the first 4 days. It wasn't until I believe February the 27th that I had to secure a residence. And so during that 4-day window, I picked him up from daycare because I didn't have a residence, and I would take him to a playground, or I took him to get McDonald's, or took him to get his first Disney Pixar car that he loves. So it was during that period of time. We weren't 50-50 until I had housing, which happened
4 days
rapidly.
after you left.
Yes, ma'am.
Were you staying at your parents' in the meantime?
No, ma'am.
Where were you staying?
At the time, my parents were very angry with me. I have a very small family. My circle of people were actually her family, Kayla's family. So I actually didn't didn't have anyone to really rely on in that nature. I did fly to Washington and stayed there for a couple of days, trying to let the emotions blow over because I didn't feel that I could stay at the marital residence. And then secured an apartment, came back, picked up the keys, and immediately went and bought a bed and a dresser for Bryce and some toys to supply an apartment.
After that happened, y'all did the 50-50 up until y'all went to court.
Yes, ma'am.
And then y'all reached an agreement to modify that a little bit.
Yes, ma'am.
And why was it modified? You heard again, Ms. Duke, and her vilifying you that that it worked better for y'all's work schedule.
It was essentially that same thing. That day, it was during an emotionally chaotic time, as you can imagine, with separating and trying to get things lined out. And there were some difficult optics around the fact that I had an affair. And so just as a temporary resolution, I agreed to the temporary parenting plan that we currently have, but with a long-term goal of always seeking equal parenting time.
She's a good mother, isn't she?
Yes,
And you believe you're a good father.
I do.
Let's talk about the day-to-day before this whole affair scenario and being unhappy
Yes, ma'am.
started. Tell me what was y'all's routine?
Our routine was that I would go to the gym in the mornings prior to my shift starting at 7 a.m. I work remotely. And then she would get him ready for daycare, and she would take him to daycare. She had to drive back from Brentwood, and sometimes timing was tight, so I picked him up in the afternoons. And then we both spent time just on the couch watching TV in the afternoons during the work week. And then we were both part of his bedtime routine. It required both of us. And so we would put him to bed approximately between 8:30 and 9 o'clock. For a while, it remained around 8:30. And then that was pretty much it. It was the same for the weekends. I would go to the gym prior to them waking up, and then so I could be there whenever they were awake. And then we would usually go either do something or hang around, ride the golf cart around the neighborhood together. So that was kind of the routine. It was much more routine, like during the week. It was much more set structure rather than the weekends were kind of.
Well, let's talk about your out of the home time. You worked as a software engineer. Who do you work for?
Everag.
And how long have you worked for them?
I've worked for them it'll be 11 years this June.
So during the whole course of your marriage, you've had the same employer.
Yes, ma'am.
And tell me, what is it that you do, sir?
I'm a software engineer. We make agricultural software that is our client, our customers' point of sale systems, like the Dixon Co-op uses our software. I'm also a team lead. I manage a US-based team as well as a contract team in India that I oversee.
Okay. And so what does that entail? You being on the phone and the computer to work?
Yes, ma'am. I don't have a whole lot of meeting heavy days. My meetings are usually short. So that, and then my shift at night is from 9 p.m. to midnight. I'm able to put Bryce down at his normal bedtime and be able to work my shift.
So what is your work day like? What days do you work, sir?
I work Monday through Friday, and I have every other Friday off. What's my typical?
So Monday through Friday, weekends off, but every other weekend you have a 3-day weekend.
Yes,
Friday,
ma'am.
Saturday, Sunday.
And then I get off. I work 7 a.m. to noon. So that's also very favorable for being able to keep.
Kind of give me a day in your life.
A day in my life. Okay.
Yeah, as far as work is concerned, you get up at 4 o'clock in the morning, midnight.
No, ma'am.
What do you do?
I usually get up about 6:30, 6:45. I don't know what level of detail, but I have my cup of coffee. I sign online, and a lot of the stuff that I do is stuff that kind of doesn't require a whole lot of interaction.
You turn your computer on and you're typing data and reading things.
Yes, ma'am.
Inputting
So,
information.
yes, ma'am. It could be coding, it could be reviewing other people's code submissions, was what I spend a lot of my time doing, reviewing work items that need to be worked on, and making sure that the team has enough work to make it through the end of the day or the end of the week, depending on how much work we have available.
So as the supervisor, you assign different tasks to different people.
Yes, ma'am.
And so that's, you're scheduling, reviewing things, but you're sitting there at a computer screen, inputting information or reviewing information.
Yes, ma'am.
And where's that office located? When you were at home,
Mm-hmm.
you know, and again, when I say home, where y'all live together.
Yes, ma'am.
Where, did you have a separate office?
It was the bonus room that was also sort of Bryce's playroom. And so that's where that we spent a lot of time. And we also had gaming consoles, both Kayla and I. And so we'd be gaming sometimes at night, and Bryce would be playing with his toys, or we'd be playing with Bryce. But also my desk was in the corner where that I worked, so I would work as well.
So 7 o'clock our time, Central Standard Time, you log on, you start working,
Yes, ma'am. 7 a.m. to noon our time,
Monday through Friday.
Monday through Friday.
And then, is that all you did? Did you said you have a team in India?
I do, yes.
And as far as I understand, again, India's on a little different time zone than what we are.
They very much are.
So did you have to also accommodate and actually get on the computer and work at odd hours because you have a foreign?
Yes, ma'am. Yep. Yes, ma'am. So at night time, I have to log on at 9 p.m. and I work until midnight.
And that's Monday through Friday,
That is also, yes, ma'am.
except the Friday when you're off.
Yes, ma'am.
So you work from 7 to 12,
Yes, ma'am.
then from noon until 9 o'clock at night,
Mm-hmm.
you're off.
Yes, ma'am.
Log back on at 9,
Yes, ma'am.
work till midnight,
Yes, ma'am.
go to bed, stop, rinse, repeat.
Yes, ma'am.
Is that it? Okay. And how did that work when y'all were together with Bryce?
That schedule actually happened right around April the 2nd. I don't remember the exact date. That had just happened
After you left?
after I left.
So when you were, so that's what you've got now?
Yes, ma'am.
And do you see that changing at any point in time?
It is possible. It's always possible that that the schedule could change, but it has been stable for over a year at this point.
So you may get a team that's not in India and you have to change your time, or is that?
No, my time would stay the same. The only thing is maintaining the teams in India. That would always necessitate the split.
Okay. So what was her schedule when y'all were, what was your schedule and her schedule when y'all were living together before you left the marital residence?
Yes, ma'am. I can start with mine. Mine was, again, 7 a.m. Until 5 p.m., and I had an hour lunch, and I worked from home full-time.
So you had more of a traditional schedule when y'all were together?
Yes, ma'am.
What about your wife's, Miss Caleb, what was hers?
Her schedule, I don't know that she had a hard start time. It seemed that she had some flexibility with the morning time, and then she also had some flexibility with leaving, but typically she was trying to leave around 8 a.m., and then she would try to leave the office around 4 p.m. and then drive back from Brentwood.
Did she have a split schedule where she works from home sometimes and in the office sometimes?
Yes, ma'am, she did. She worked 3 days. It was Monday, Tuesday, Thursday in the office, and she worked 2 days remote. That was Wednesday, Friday.
So Wednesday, Friday, y'all were both in the house together,
Yes, ma'am.
and otherwise she would leave. So during that period of time, Bryce, y'all married in 18, bought the first house.
Yes, ma'am.
And when did y'all get, and you were working at this job and had been remote the whole time, correct?
We went fully remote in 2020
2020.
because of
So a couple
COVID.
years after, but before Bryce was born in 2020.
Yes, ma'am, correct.
Okay. And then your wife had worked as an LPN, but in a cosmetology type setting at that point in time, and then she moved. When did that happen?
Yes, ma'am. So when did she move? Well, I think so. Originally, she went to LPN school and had just graduated right as we were moving into the apartment. And I think she spent a brief stint at a nursing facility, an NHC. That was a little bit of a drive. And then she got, I don't remember the exact dates, but she got the job working at a cosmetology surgery center. And then I don't know, it might have been somewhere close to 2019-ish where that she got the job at Medify.
But from the time that Bryce was born, she's been at Medify and you've been at your company.
Yes, ma'am.
So when Bryce came along, did she have this 2-day at home, 3-day schedule?
I don't think so. I think that, I can't remember the exact schedule, but because she got promotions, there were different expectations. And so I think that they have, she started as a care coordinator, and eventually they started allowing them, I believe, to work fully remote. And so I think that she only spent a brief time where that she was fully remote, and then she became a team lead. And I think they may have required them to come into the office for 1 day a week or something. I'm not exactly sure the exact number. And then her next promotion required her to come in 3 days a week. I believe that's correct, but that could be a little.
So in September of 20, y'all became pregnant, and in September, y'all were blessed with Bryce.
Yes, ma'am.
So what was y'all's schedule? What did y'all do at that point?
To be able to take care of Bryce.
Yeah.
During that point in time, I was working fully remote, and we had coordinated and got daycare for Bryce to have it ready for whenever her maternity leave ran out. I also had paternity leave for the first 6 weeks. So then after her maternity leave ran out,
How long a leave did she have? You had 6 weeks.
I had 6 weeks. I believe it was 3 months. It might have been 4. I don't recall the exact amount. I think it was 3 or 4.
But y'all were both at home. You took time off. She took time off.
Yes,
Then
ma'am.
you went back to work first
Yes, ma'am.
at home,
Yes, ma'am.
and then she went back to work.
Yes, ma'am.
So what happened at that point in time?
At that point in time, we started taking Bryce to daycare.
And you were still during this period of time, even before, I think you said in 2020 when you lost your grandfather, you started focusing on your health and working out.
Yes, ma'am.
And so did you continue, were you going to the gym then?
Yes, ma'am. The first 6 months I was actually running, and then it turned out that I didn't like running that much, and so I started going to the actual gym. And so I'd been doing that since probably somewhere around January of 2021.
And would you go at different times, or did a routine develop?
A routine developed. I like to try to go at the same times if I can, and I would go during my hour-long lunch.
Okay. So you would leave, you would work and then go. When did you start getting and going early in the morning?
I did that. I had a couple of stints where that I tried going in the mornings and then would flip back. But I really started going in the mornings.
This courtroom battle quickly turned into a heated custody fight when a father accused of abandoning his family took the stand to defend himself. The mother's attorney claimed he chose an online affair over his wife and young son, even flying across the country to be with another woman while his family was falling apart. The courtroom fell silent as details of the relationship were revealed, including secret messages, trips to Washington state, and allegations that he put his new romance ahead of parenting responsibilities. But the father pushed back hard. He admitted to the affair, yet argued that he had always been committed to his son and had shared parenting duties from the moment he moved out. He described buying a family home, investing his inheritance into their future, and maintaining a close relationship with his child despite the divorce. With both sides painting completely different pictures of the same father, the judge was left to decide one critical question: what custody arrangement would truly be in the best interest of the child?